Counsel, that earlier case, Swift, I think you said was the name?
Yes, Swift from the Fifth Circuit.
I haven't read it, so I don't know anything about it. But it's not an issue of keeping in touch with the state authorities. The warrant of absconding should have been issued a warrant should have issued the moment they learned of the state law conviction, correct?
Yeah, so that case involved a very idiosyncratic fact pattern of a person who served a federal prison sentence and then served a state prison sentence for many years and then was released and actually did report to his state probation officer. And apparently he didn't realize, and the federal government didn't realize, that he also had to simultaneously start this term a federal supervised release. And apparently no one from the federal...
Oh, that really is idiosyncratic. Okay.
So, yeah, so there haven't, I mean, that is just an unusual case. It happens to be pending on certiorari right now, but we haven't found any cases like that since 1984 other than this one. So, you know, and the government cites other exotic fact patterns where a warrant wouldn't issue during the term, such as if there's an administrative error in obtaining the abscondment warrant. And yes, theoretically that could happen, but you know, it doesn't happen very often. And in the ordinary case like this one, it's perfectly appropriate for the probation officer to get a warrant.
In that Swift case, you have to deal with the language of the statute, which requires a warrant to have issued before the expiration of the date.
Exactly, but in this case, the warrant did issue based on her abscondment, and so we agree the sentencing court absolutely had the jurisdiction after the expiration.
Right. Thank you, counsel.
But, okay, yes, Your Honor. So let me just make one other point about the structure of the statute that I think supports our position. That's rooted in Section 3583I, the tolling provision we just talked about. So that's not only about abscondment, but abscondment is one common scenario in which that statute would arise, because the statute says that if a warrant issues during the term, then the sentencing court retains jurisdiction after the expiration of the term to revoke supervised release. So ordinarily, you wouldn't have the situation where the warrant issues during the term, but the hearing happens after the term because the probation officer knows where the supervisee lives. So, you know, the warrant can be executed very swiftly. But one situation in which it couldn't be executed swiftly is when the person has absconded. So the warrant issues during the term, but they can't find the person until after the term expires. And yet, even in that context, the way that Section 3583I is set up is it assumes that the term is going to end, and then after the expiration of the term, there will be this revocation hearing that rewinds the clock to the beginning. And I do think that's inconsistent with how the government is looking at things, which is that the term never ends once the abscondment occurs. And so, you know, that's just an additional piece of structural support in the statute that I do think militates in favor of our position. If there's no further questions, I'm